versatility.
I know people will be flowing in and out of it throughout the day, and people are still joining us. But let's get this party started. We have a terrific group of people today talking about some of the most important issues of our time: the constitutional rights of corporations and money in politics. And we have people coming from a variety of really fascinating perspectives. Academics that work in corporate law, constitutional law, and election law. We have people that work on the ground on these issues as lawyers and as advocates. And we are really honored today to have Chief Justice Leo Stein of the Delaware Supreme Court. So we are also having jurists representing this group. It's a really terrific intersection and dialogue that we hope to have. I want to thank Open Society Foundations that has helped us make this program possible, and also our co-host, We Speak for People, that has been working with me on this event. And it's so wonderful to see this day happen and see these interesting people come together to talk on these important issues. So with that, I'm going to turn it over to Ann Tucker, who will be moderating this first panel. And I want to note that you all have programs with the speaker biographies. And because we have these great people together in the room at the time and somewhat limited time, I think we're going to dispense with the formalities, even though this group of panelists is obviously extremely distinguished. And it's just that we could go on and fill the hour and 10 minutes with all of their credentials and start getting to the meat of things. So I'm going to turn it over to Ann and give her permission to get right into it with this terrific panel.
Thank you, and thank you to Elizabeth and to Loyola Law School for having not only us as the panelists, but everybody that's here today to participate in this conversation, as well as the groups that are behind some of the thinking, Free Speech for People, and Open Society Foundation as well. So we've had the benefit of starting this conversation, or as Elizabeth called it, the party, a little bit before getting in front of this broader audience. And we were discussing in part questions of line drawing earlier today. So I want to start perhaps in the middle of the conversation that we've begun and open up this question of line drawing. It's one of the biggest and most challenging in the inherent debate about corporate constitutional rights. And everyone's work up here has drawn in some respect on these questions of lines and organization. So Margaret Blair at Vanderbilt has focused on derivative rights and instrumental rights as a basis for making these distinctions. Adam Winkler seems to have endorsed some of these derivative rights and categories in his work, but he may push back on the implications of that. James Nelson has looked at associational interests and purposes of organizations as one set of lines. And Sarah Haan has looked at the difference between the interests of voters versus shareholders. And Erwin Chemerinsky has famously focused on the question of whether the extension of constitutional rights serves the protection of minority interests or not. So what I want to ask this group, who's engaged in some of this heavy work on line drawing, is where's your thinking today? How should courts make distinctions for purposes of extending or limiting corporate constitutional rights? How would you propose that we draw these lines? And let's start with Adam and work our way down the panel, please.
Well, thank you so much. A great honor to be here, especially to be on this panel with such terrific people, and great to see all of you out here interested in this topic. The line drawing question is really an important one because I think when push comes to shove, many of us will agree that at the end of the day, corporations have to have some rights under the Constitution. We might disagree about how they get there, but at the end of the day, they'd be able to claim them in some way, shape, or form. Corporations need to have property rights. If the state of Georgia decides to build a freeway through the Coca-Cola bottling factory, it has to pay just compensation to Coca-Cola, but only if Coca-Cola has a constitutional right to that property. If the state of Alabama decides to try to silence the New York Times, it can't do that because the New York Times has a constitutional right as part of the freedom of the press to speak. And if some company gets prosecuted for some criminal offense, it's only because that corporation has constitutional rights of due process that it is guaranteed due process of law, has the right to counsel, maybe a right against double jeopardy, etc. So we know corporations must have some constitutional rights. I don't think that necessarily means that corporations must have all constitutional rights. I think we've seen in recent years the expansion of corporate rights into areas where corporations are needlessly given expanded rights. Citizens United gave corporations the right to make political expenditures in candidate elections. The Hobby Lobby decision, although it's not a constitutional rights case, nonetheless based on constitutional principles of religious freedom, the court said Hobby Lobby has religious freedom rights. I think that one thing that Hobby Lobby did was make a very interesting move in terms of line drawing, though. It recognized that even within the category of corporations, so one thing you need to do is there's a category of rights, and we need to figure out which rights corporations should have, but then we also have to think about which kinds of corporations should have which kinds of rights. And in Hobby Lobby, the court sort of suggested, although did not stick to the idea and didn't make a firm statement about it, but kind of suggested that Hobby Lobby has religious freedom rights because it's a closely held corporation, and that a publicly held corporation, one whose shares are traded on the public market, would not be able to necessarily make the same religious freedom claim. Again, the court didn't say that's absolutely, it wasn't a holding, but there was at least a suggestion by the court, which suggests a different kind of line drawing between different kinds of corporations within the category of one right. Closely held corporation versus a publicly held corporation. Another kind of line along those lines that we have to figure out and think about and take seriously, perhaps, is a distinction between for-profit and not-for-profit or tax-exempt organizations, depending on how you want to frame it. One of the problems, I think, one of the things that's led to the expansion of corporate rights is the idea that in early cases the Supreme Court protected the rights of nonprofits. And membership organizations that were formed as corporations, and then in later cases involving for-profit corporations, used those ideas that came out of nonprofit corporations to expand them to for-profit corporations. I think we need to do a better job thinking about how we distinguish between and different kinds of corporations within the Constitution. My suggestion for how we would go about doing that is, as some of the people here who I've talked to before know, my view is that we need to recapture the idea of corporate personhood. We need to focus on the nature of the corporation. What kind of corporation is it? What kind of rights should that kind of corporation have? And address that question directly. One of the problems with the jurisprudence is that the court has often hid the corporation or looked beyond the corporation, either piercing the corporate veil and protecting the rights of the people who are associated within the corporation. That's kind of what Hobby Lobby does. We need to protect the Green family and their assertion of religious freedom through the corporate form. Or in other cases, the court is focused on things like listeners' rights and granted corporations' rights without directly addressing what kinds of rights the corporation should have. I think it's kind of become a mess. What we need to do to clarify it is to very focus specifically. What kinds of rights should a for-profit corporation have? What kinds of rights should a for-profit corporation have if it's closely held? What kind of rights should a nonprofit corporation have? Or maybe a tax-exempt organization, if that's the way we want to frame it. But those are the kinds of divides that we need to make to distinguish between membership organizations. Exxon is not the same as the Sierra Club, even though they're both corporations, and we need to start drawing those lines. I think the way to do it, and we can talk about this more, is through recapturing the idea of corporate personhood and reframing it in a more useful way.
I, too, am very grateful to be invited here. I want to thank Elizabeth, and I'm so honored to be part of this panel and part of this conference. I would answer the question differently than Adam, but I don't disagree with anything that Adam said. I think that line drawing has to be based on why we want to protect corporate rights. And I think the Supreme Court has given very different answers to that. In First National Bank of Boston versus Bellotti, which is really the first time the court said that corporations have free speech rights, the court's answer was entirely instrumental. The court said, we protect corporate free speech because the more expression that's in the marketplace of ideas, the better we serve the goals of the First Amendment, the better it is for society. And in fact, in Citizens United versus Federal Election Commission, when the Supreme Court said that corporations have the right to spend unlimited amounts of money out of the corporate treasury to get candidates elected or defeated, The court repeated the analysis from Bellotti. It said we protect corporations because the more speech that exists, the better it serves the purpose of the marketplace of ideas, the better informed everyone in society is. But if you look at Hobby Lobby from 2014, it gives a very different explanation for why there it's protecting religious freedom, albeit under a statute, the Religious Freedom Restoration Act, rather than under the Constitution. Justice Alito's majority opinion there says that the owners of a business should not have to give up their free exercise rights by choosing to incorporate. So it's not at all about the instrumental notion that existed with regard to speech in Bellotti, in Citizens United, but instead it was this idea that when people choose to incorporate, they should be able to imbue their rights onto the corporation. I find that very troubling. I think it ignores the difference between a corporate entity and the owners of it. I've often wondered if now individuals will try to pierce the corporate veil by saying that if they can imbue their religious beliefs onto the corporation, it's not really a separate entity anymore, and they should be liable for the debts of the corporation. The corporation itself as a separate entity is a fictional entity, and that's a fictional entity that can't have religious beliefs or religious conscience. There's no instrumental reason, like there is for speech, for giving religious rights to the corporation. And in fact, I find no stopping point to the analysis in the Hobby Lobby case. Traditionally, corporations have not had the Fifth Amendment privilege against self-incrimination. But if the owners of a business don't have to give up their free exercise rights by choosing to incorporate, why should they have to give up their privilege against self-incrimination by choosing to incorporate? Corporations traditionally have had very limited privacy interests under the Fourth Amendment, but why should the owners of a business have to give up that by choosing to incorporate? Now, one place that I disagree with Adam is his saying that Hobby Lobby is really a decision just about close corporations. He's right, of course, that the court phrased its holding in terms of close corporations. But Justice Alito's argument is not that other type of corporations could not claim the benefit, but he says it's unlikely that other types of corporations would want to claim protections under the Religious Freedom Restoration Act. That doesn't mean they couldn't do so. And I'm not sure, in terms of the reasoning the court gives, there's any basis for drawing a distinction among the types of the corporations. So my answer to the question you pose is to say corporations do not deserve constitutional rights from an intrinsic perspective. That the reason individuals might have rights is there's an intrinsic benefit, a dignity benefit, other benefits in saying individuals are entitled to these rights. And if there were more time, I could develop a whole theory of rights as to why there is an intrinsic benefit to rights. Corporations don't have rights from an intrinsic perspective. For corporations, the question has to be always, is it instrumentally desirable to give those rights to corporations? I think in terms of freedom of the press, I think that there is an instrumental reason for protecting the press and their rights separately. When it comes to property, I could make an instrumental argument. I think when it comes to Citizens United or Hobby Lobby, I would argue that the instrumental argument cuts the other way, but I think the analysis, the answer to the line drawing has to be is, when is it instrumentally desirable? And that's what we should be focusing on and talking about.
Right. Jane?
So I agree with a great deal of what's been said, and I wanted to highlight, sort of following on those comments, the methodological point, which is that I think it's important in determining whether corporations should have rights claims to start with the particular right at issue, that is to say, the particular interests that ground a right to speech or religion or other kinds of constitutional rights. They might be different interests. And so then rather than starting, as some are tempted to do, with grand theories of the corporation and then trying to tease out whether they have all the rights or none of the rights from that grand theory, I think it's important to start with the interests that ground, say, religious freedom rights or speech rights or freedom of association rights, and then ask how those interests play out in different organizational forms, and how the forms either encourage or discourage or distort those interests or promote those interests. And I think that's the methodological way to start normatively justifying the lines that we might draw. Now, I've defended the idea, at least in certain contexts, of drawing a line between for-profit businesses and nonprofit organizations. And I've done so based on the sort of fundamental dividing line between nonprofits and for-profits, which is known as the non-distribution constraint. The idea that in nonprofit organizations, insiders are not allowed to basically use the corporation to benefit for private endearment, to benefit private shareholders of the organization. They have to act to promote the interest of the organization. Now, my view is that this line is not perfect. That it's a proxy for these interests and values that we care about, in particular in the religious liberty and in freedom of association cases. So it's not perfect, but it's a pretty good proxy for those values. And the last thing I think with regard to the for-profit and nonprofit distinction is that nonprofit status, in my view, ought to be a condition for being eligible to claim these rights. So if you're a for-profit, you're out. If you're a nonprofit, you get to raise the claim. That's not to say you win. That is to say you're within the coverage of the rights claim, and then you get to test it out against competing interests. And so I think that's one productive way to at least start drawing lines in this area.
So let me say thanks to Elizabeth and to the Free Speech for People organization for making this event possible. It's nice to be in Los Angeles before El Nino causes the whole place to go, the mudslides to start next January and February. So anyway, I've written about corporations and the historical emergence of corporations over back 250, 300 years ago, and I've focused in some work I did jointly with Elizabeth on the development of constitutional rights for corporations. And one of the things that strikes me as really important is, as has already been said here, is that not all corporations are alike, and that corporations are organized for different things. They have different parts of the statute that they appeal to. Where I would go with this, whereas Adam has suggested that we take corporate personhood more seriously, and we recognize that the corporation is truly separate. If it's truly separate, it doesn't necessarily have the same rights as its individuals. Another promising direction, I think, would be to take seriously what the court said it was doing in these cases, which is that it was thinking of a corporation as an association of people, and looking there's an instrumental rationale for sure, as Erwin suggests, but there's also this derivative rationale, which is that we're recognizing that the courts have rights because we would recognize that any one of the individuals who we think the corporation represents would have those rights. And then in Hobby Lobby, the court said the individuals that we're looking at are the shareholders, the five shareholders, the five members of the Green family. Of course, in Citizens United, there were no shareholders. It was a nonprofit organization that they were looking at. But the court wrote the decision broadly, suggesting that the same decision, that the same basic principle would apply to for-profit corporations and to widely held corporations and to all kinds of corporations. And I think that failure to discriminate is really important. I would suggest, given where we are in terms of the history of this, we might not be able to go back and undo very much, but that we should take very seriously the court's statement that it's treating a corporation as an association of individuals, and we should insist that where a corporation exercises an expressive right, we have to identify exactly who are the people behind the corporation that the corporation is allowed to express the rights on behalf of this group of people. And so the same as we have in television ads for politicians, the politician who's running for office, a candidate has to come on and say, I'm Margaret Blair and I approve of this ad. We should be able, if a corporation is going to be allowed to make expenditures in the political process in particular, but I think this might apply more broadly, they should be required to publish, which they can do online, so it shouldn't be, the publishing part shouldn't be expensive. Exactly who are you talking about? Who are the people behind this? Who are the specific people whose rights are being implicated here, and who is it that the corporation represents in taking these particular actions? If that means identifying the shareholders, okay, suppose the corporation that's doing the political spending is a subsidiary of some other corporation, you'd have to say, well, we're representing the shareholders who are the larger corporation, and they in turn are representing the financial institutions that are invested in the corporation. The corporation would be required to specifically identify. If it's a closely held corporation, who are we talking about? Who are those people? If it's a nonprofit corporation, who were the investors who put the money up? We need to name people because my biggest concern about the money coming in into politics through this avenue is that it allows people with enormous amounts of money to be able to act anonymously in the political environment. And that also cuts the other way, in that if the rationale that the court is giving for granting political speaking rights to corporation is that we need to enrich the marketplace of ideas, and we need to make all points of view available. Which Elizabeth and I have called what's our word? A derivative rationale, or a instrumental rationale. If it's the instrumental rationale we're talking about, the only way that a listener can evaluate the speech and decide what they think about it is they have to have full information about who's saying it. So precisely who are we talking about, and where's the money coming out of, whose pockets is the money coming from in order to make this speech possible?
I am also very honored to be here, and going last on this question, of course, has allowed me to appreciate the interesting differences in all of your perspectives, and so it underscores for me how when we gather a group of very knowledgeable, esteemed law professors on this subject, they can come to such different conclusions about where lines should be drawn. Line drawing has not featured prominently in my own scholarship. But I will say that I am most persuaded by Justin's point of view about the nonprofit, for-profit divide. I think we have a long tradition of viewing for-profit activities in a different light than nonprofit activities. That's why we only obtained the commercial speech doctrine in the 1970s. And I share, I think, the view of a number of the panelists in being especially suspicious about the closely held, widely held line that the Supreme Court tried to draw in the Hobby Lobby case. I think that is a particularly bad line to draw, and I hope we move away from it.
Thank you. So in answering this question, we've highlighted some areas that would have natural outlets in litigation. So we're identifying ways in which jurisprudence could change in a way that might help us draw these lines. And unsurprisingly, specifically, Erwin, your approach about saying we should really be asking this question about instrument. Is this instrumentally important versus an intrinsic-based right? That certainly strikes me as a jurisprudential point, something that could be the result of litigation. What strategies or what of these lines that we've identified could be achieved outside of the courtroom, utilizing a legislative process or maybe even an agency-based process? So, Margaret, I heard you talk about the need to document a corporate process or document an entity-based process so that we could identify what a corporation's political identity, its religious identity or intent is. So I'm going to put you on the spot and ask you, do you see your line drawing as having an outlet in state law or in an agency approach?
Okay, so I think it's less important that we identify, that we try to force corporations to categorize themselves as being either religious or any other category. It's less important to do that than it is to be able to, that the corporation must articulate and make public who the people are that the corporation supposedly represents in making its political speech or engaging in these expressive activities. And if those so you know there's some concern about, I grant this, that if the corporations were to have to name names, the ACLU would have, I don't mean the ACLU, the NAACP would have lost the protection it had in the cases early in the middle of the 20th century, where it claimed that to have to reveal its membership list would in effect take the freedom of association away from its members. So being sensitive to that, nonetheless, it was clear in the NAACP cases that the people who were members had joined for political reasons. They had joined specifically for expressive reasons. And so to identify them as the members, but when we're talking about a for-profit corporation, who is it that the corporation is speaking for when it's participating in political speech? Is it speaking for its shareholders? Who are its shareholders? Is it speaking for its management? Who are the management that are supposedly that the corporation is speaking for? Is it speaking for its employees? If so, we can identify the quite specifically the class of people that are being talked about. If it's a closely held enterprise or an organization like Citizens United was or is, Citizens United still exists as a nonprofit corporation. Who are the investors, if you call them investors, the donors who put money into that organization? The public needs to know that in order to evaluate the speech that is the political speech that is generated by that organization.
Yeah, I think it's a good question, and I think it is. Well, while I'm hesitant ever to rely on legislatures to do something in this particular political environment, especially Congress, I do think there is a long established tradition of using legislation to differentiate between different kinds of corporations and give them and afford them different rights. That's what the tax code does. There's a big difference between a for-profit company and a 501c corporation. A 501c3 will have different rights than a 501c4 in terms of what kinds of political expenditures they can make, what kind of rights they have on these fundamental issues. So I think it is possible that legislation can do that. And the tax code provides us with one way of thinking about it. One benefit of thinking about I don't want to say the tax code is the be-all, end-all of how we think about this or just the anchor, but it does highlight that we can do through legislation, recognize there are different kinds of corporations and afford them different rights under the law. And what we do is we say, okay, if you want to form a religious corporation that has religious freedom rights, then you organize in a certain way, under a certain provision of the tax code, for instance, or you fit under a certain definition of the tax code. It enables the Green family, for instance, behind Hobby Lobby, if it wants to form a religious corporation, and a religious corporation should have constitutional rights. There's no doubt in my mind. Many religious churches are formed as corporations. There are religious nonprofits out there that clearly should have a constitutional right to free religion. But what we do is we make them choose a form that recognizes that they have those rights. And I think if Hobby Lobby had organized as a religious corporation, there's no controversy about whether it should have religious freedom rights. In fact, the court has upheld the religious freedom rights of many religious corporations in the past, and it's never been controversial on this ground. It might be controversial on other grounds, but never controversial on the fact that a corporation gained a constitutional right. So I think legislation can be, I have no hopes for legislation right now, but conceptually legislation does this, has done this for a long time, and can do this in the future.
So Adam, one of the unique features of corporate law is that it's individually made at the state level, but then corporations intersect with federal law through securities laws, IRS regulations, and other regulatory environments. So do you see the focus in your answer as being one that happens at the federal level and not at the state level?
Right. That's an interesting question. I think probably the most effective answer is at the federal level because it'll provide more uniform treatment of corporations across state lines. But I don't know. I haven't really thought too much about whether I would prefer the federal or state approach, and I think I could be convinced one way or the other. One issue with the state approach is that it would give the state, there's a famous story of the race to the bottom in corporate law. And that's the idea that if you have competition among states for corporate charters, corporations will incorporate in the state that is the least restrictive for management and leads to a race to the bottom where we have fewer and fewer effective limits on what corporations can do. That's been challenged as a story. Maybe it's a race to the top, not a race to the bottom. But generally, there is the story of competition that has generally led to, at the state level, to a diminishment in these protections. Being that a corporation, if it wants to move from California to Delaware, just has to file a form, it's probably likely that if we do it at the state level, there's going to be states that don't provide these kinds of restrictions, and corporations that are seeking to take advantage of the law will move into those states where less restrictions exist. So again, I'm probably more favorable to a kind of federal level way of thinking about it than a state level, but like I said, I want to be open-minded to it.
Okay. Erwin, I saw you want to chime in.
I also believe that legislation is possible and desirable, but the kind of legislation that I argue for is different from the other panelists. Let me give an example. I think a state, in fact, a local government, Congress, could adopt laws that say that corporations that do business with that level of government cannot spend money in getting candidates elected for that level of government. So the city of Los Angeles could adopt an ordinance saying, if you're in a contract with the city of Los Angeles, you can't spend any money, not only can't contribute, you can't even expend money to get candidates elected for city office. A state could do that, the federal government could do that. And I think there's an analogy to this. The Hatch Act at the federal level says that if you go to work for the federal government as a civil service employee, you can't participate in partisan political activities. And the Supreme Court has upheld that as constitutional. Many states have similar laws. So I think the argument that it would be an unconstitutional condition to restrict corporations in that way is answered by, well, we accept it already for government employees, and we have since the 1940s. I think there are other things that can be done at the local, the state, or the federal level. I look at what Seattle recently adopted in terms of a public funding scheme with regard to elections. I think that states can adopt stricter laws with regard to requiring that shareholders approve the expenditures with regard to political campaigns. As I hope we get a chance to talk about, the Supreme Court has been so aggressive in recent years in wanting to protect non-union members from having their money spent in a way that they disagree with. Well, why not have similar concern about dissenting shareholders and protecting them from having their money spent and they don't want, as well as corporate disclosure things that have already been mentioned on the panel. That can be done at the state as well as at the federal level. The benefit of the things that I'm outlining is the more it requires federal action at this point in time, the less likely it is to happen. The more it can be done at local levels or state levels, the more likely it is to happen, which is why I argue for those things. And here, I've got to say, I blame progressive organizations like People for the American Way and Common Cause. They have focused so much of their attention on wanting to try to get a constitutional amendment to overturn Citizens United. There's not going to be such a constitutional amendment. You're not going to get 2/3 of both houses of Congress and 3/4 of the states. And I'd much rather that organizations like that focus their attention on what kinds of progressive legislation might be adopted at the local, state, as well as federal level.
Quick question on that point, and that is, as law professors, do you think we are fixated on the ultimate outcome that happens in the court and overlook the value of engaging the broader population and individuals in these debates, so that there's value in pursuing different paths by, not from our perspective of saying, did a law pass, does this law meet our ends, or has a court sided with us and cited this brief that we've submitted, but is there a strategy to be had in engaging a broader group of people on these issues?
I will not generalize any criticism of law professors. Law professors are involved in many different ways, but I would hope that if people paying attention, I'd say law professors in the future will try to get involved in these kinds of efforts. As long as the 5 conservative justices who wrote part of Citizens United are there, we're not going to overrule Citizens United in the Supreme Court. It's not going to happen. Any litigation is in the shadow of those 5 justices are there. There's things that can be done through litigation, but I think there's a lot more that can be done at the legislative arena, local, state, and federal.
Margaret, Sarah, James, anything to weigh in on this?
Sure. I wanted to note not sort of legislative strategy, but a legislative development that I'm interested in, and I'm not sure which way it cuts, which is the development in many different states of benefit corporation legislation, which is a sort of hybrid, and it sort of threatens to make even blurrier the distinction between for-profit and nonprofit organizations. And in fact, in the Hobby Lobby case, Justice Alito points to this kind of legislation as evidence that for-profits can do all types of things, including religious activity, and so there's not much to the distinction. But if benefit corporation legislation were to continue to proliferate and maybe solidify and get worked out in terms of more detail, there's a possible sort of other way that they might be read, which is to say they provide an ex-ante organizational choice of form, which is to say that if you don't become a benefit corporation, that's a signal that you want to be just an ordinary for-profit business, and such that if you are then claiming in litigation other kinds of interests and rights to resist regulation, that there might be either an insincerity worry, or at the very least, you decided that this was not the kind of organization you were originally. You can sort of sort yourself into another number of different forms. You don't have to become a nonprofit and forego some of the investment capital resources, but by not becoming a benefit corporation, you would signal that you are becoming a business for business, and that could help clarify some of these what seem to be borderline cases and more difficult line drawing questions.
Absolutely. And many states currently also have 20-some states have closely held entity statutes where entities, corporations can elect to be recognized as closely held, a distinction that the court did not rely upon when they used the phrase closely held in Hobby Lobby. But it is interesting to think about existing statutory categories that may assist us in that process. Of
course, the statutory closed corporations are, let's just say, underused.
Certainly.
Many that are easily recognized as closed corporations, including ones in the Hobby Lobby litigation, were not organized under closed corporation statutes.
And I think any law student or current lawyer may remember that there's a big distinction when we talk about a colloquially closely held entity versus a statutorily closely held entity, and that while we muddle those concepts a lot of times when we're speaking about them, that they do have distinctives. Sarah, you wanted to weigh in?
Yeah, we part ways on this. So it seems to me that the benefit corporation is just a flavor of for-profit corporation. There's not very much actually that distinguishes the benefit corporation from ordinary corporations. And I would not favor allowing these kinds of existing statutory categories to draw lines for purposes of allocating rights. In particular, because I feel like we want to have these statutory categories so that when business people engage in enterprise, they can choose a form of entity that is pursuing their business objectives without worrying that by choosing a particular type of statutory category, they have to forego some business advantage or some capital formation advantage in exchange for buying some subset of rights. So I would feel cautious about using the closed corporation, the statutory closed corporation, or the benefit corporation as some sort of rights-based distinction. And again, and just to underscore that point, the benefit corporation is a for-profit form of business.
Can I just ask, so I'm curious why you think it's so problematic. So if you want to form if you have a nonprofit, you want to form a 501c3, you're going to have different rights than you have your 501c4. And it deals directly with your ability to accumulate capital, right, in terms of whether they're going to get a tax exemption for if they give you the money or not. And we recognize that 501c4s have greater political speech rights than 501c3s. That seems to me a pretty common sense way of going about distinguishing different kinds of entities by giving those who form the entity the option. You can choose to 501c3, you can't do that much political work. You can form a 501c4, you can do lots of political work, but makes it a little bit harder for you to gather up your capital. And that seems like a pretty well-established, relatively easy way to go about doing it. So I'm curious why you're so skeptical, Sarah, about that idea of forcing business owners to choose one path or another.
Well, I think this is going to impose costs on business if their needs change over time. And so I guess what I'm sort of imagining, what you're describing is maybe a set of many categories of different type of entity, where you're really selecting from a menu of sort of governance structures and economic rights on the one hand, and constitutional interests, constitutional rights and protections. They sort of would go hand in hand. And so you could have, I mean, theoretically, you could have a big menu of different kinds of forms of entity, right? For-profit forms of entity. But from a business person's point of view, I think that there is value in having a great deal of flexibility and not having sort of cabined yourself into a particular subcategory, and then a few years down the line you realize you need to raise more capital and you need to attract a certain set of investors, and so you need to change, all of a sudden you need to change your form of entity, or you need to re-examine your statutory category every couple of years. And that would seem to be problematic from an enterprise or business point of view. But I'm curious to see what other people think about that.
So what I hear from this panel is the value of categorizing entities, right? We have this monolithic label of corporations, and that underneath that exists all these different variations, and it's not even distinct categories. It might be more of a sliding scale from a purely for-profit large company all the way down to a small nonprofit. And that by categorizing our entities, it may help us facilitate this instrumentality review that Erwin talked about, but also that's consistent with what you advocated, James, by saying what we need to do is methodologically look at the different forms and ask, how are these rights and these questions played out within that form? So even though everybody's coming at this from different perspectives, it seems like it seems like there's some general support for that. Does anybody want to push back on on that character?
Yeah, so I've got a paper that I turned into the editors months ago, but nothing's happened with it. So I'm not quite finished with it. But I launched into this question of, okay, let's think about the ways that you could carve up different kinds of corporations. I draw the line among types of corporations, and you start looking at all the different things that exist under a category of 501c. Say just as a first cut, 501c corporations, they can range all the way from a political organization like Citizens United to a big health hospital, charity hospital, to schools, to local community groups, to tennis clubs and chess clubs, and trying to establish which one of these types of corporations actually speaks for its people when it articulates. It's not always clear. And you go on the for-profit side, you've still got an incredible array of possibilities, although we only have really one major body of state by state, but each state has one body of corporate law that governs for-profit corporations. But you also have corporations that form subsidiaries, and the subsidiary is a separate corporation, and the subsidiaries may form further subsidiaries, and they may do joint ventures, and they you have individual corporations that range all the way from somebody who starts a landscape business and wants the benefit of limited liability, but it only has 2 employees, to special purpose entities that were used on Wall Street as a ways to carve up assets and identify which pools of assets were available to pay which debts. And I found that it was not particularly useful to me in terms of thinking through what rights they should have. Now maybe there's a simple way to cut through it, and I just haven't found that. But I found it was not as helpful to me to think about what kind of corporation as it is to ask the question, who are the people? And if you can't find actual human flesh and blood people that you can say are represented by a given corporation, then that corporation should not have any expressive rights at all.
Right, so I'm going to characterize yours as the heartbeat approach, right? You want to be able to find the heartbeat behind it.
Exactly, that's a good way to put it.
So I'm hoping, I want to ask 3 specific corporate law questions to this group of panelists, if we have time, focusing on corporate social responsibility, securities disclosure, which don't doubt will actually be a very interesting discussion, and also the commercial law doctrine, if we have time. So I do want to ask a question of this panel. So an interesting debate post Citizens United and post Hobby Lobby has been, can you oppose this notion of corporations having unlimited election speech rights and having expanded religious identity rights? Can you be against those propositions, but then for companies like Warby Parker, Tom's that have the buy one, give one policies? Can you proudly wear your Patagonia wear? And can you support corporate social responsibility and still be opposed to these results? So I think that's a really interesting question. I want to see what our panelists have to say. Sarah, do you want to kick us off on this?
Sure. Well, it is my view that corporations do not promote values except in the service of profit making. And so I guess I am skeptical in general that when you see a corporation engaging in CSR, corporate social responsibility activities, what you're seeing is a company whose management has made a series of decisions about the way the corporation should engage in its operations, essentially to promote profitability. And this idea that sort of the shareholders should be able to do something else to promote a more extensive set of religious or expressive values troubles me quite a bit. So I'm interested to hear if that was too provocative a thing to say, or...
I disagree. I actually think that the question is comparing two very different things. One thing we're talking about is, when is a law that's applied to the corporation a violation of the Constitution or a federal statute? So in Citizens United, the question was whether the McCain-Feingold Bipartisan Campaign Finance Reform Act impermissibly interfered with corporations' free speech rights. In Hobby Lobby, the question was whether or not the regulations under the Affordable Care Act interfered with the Religious Freedom Restoration Act rights of the corporation. And that's very different from me of the question of, can a corporation on its own choose to pursue social responsibility? If the law mandated social responsibility actions on the part of the corporation, then we might get to the free speech issues or the religious freedom issues. But with corporate social responsibility, we're choosing then, what can the corporation do on its own? I reject the notion that corporations exist just for profit maximization. I believe that corporations can choose to exist for many purposes. All types of corporations can make that choice, and they can decide at times that they'll lessen their profits to do what they think is best for society. And I hope they'll make that choice.
So I think that there are at least two ways that you can consistently hold a view of opposition to Hobby Lobby and embrace of CSR, which is at least the result of Hobby Lobby. One is to view it as sort of the view of the corporate law professor's brief that was filed in Hobby Lobby, which is to say that the fundamental nature of corporations is the separation between ownership and control, between shareholders and the managers, and that this fundamental separation means that you can't look to the shareholders, you have to look to the organization, and so that's why there's no religious liberty right. I don't think that is in significant tension with an embrace of CSR. I also think that another way to support, or I should say to oppose the Hobby Lobby result, is if you oppose the Hobby Lobby result on grounds that it impermissibly infringes on the interests of third parties. The interests of employees, the interests of women's equality and women's health. That seems perfectly consistent with the ideas of the corporate social responsibility. There's no tension there. But if you oppose the Hobby Lobby result because you think that for-profit corporations aren't the kinds of organizations that promote values other than business values, then I do think that there's a significant tension between that approach and a full-on embrace of corporate social responsibility.
So let's, I do want to ask a question focused on mandatory corporate disclosures. So Exxon has recently been in the news coming under scrutiny for their climate change disclosures, and there's a question about whether or not they may face some liability for the veracity of those disclosures. And so disclosures comes up in several different contexts in our conversation today. So one, disclosure requirements were left intact in the Citizens United opinion, and disclosures are they are a remaining leg of campaign finance. It might be a weakened leg, or it might be an endangered leg, but it is an existing leg that remains standing in campaign finance. And it's also in a growing area of activism in securities laws, where public companies have to make an increasing number of disclosures regarding things about conflict minerals, CEO pay, and in some respects, questions about what their policies are, like in Exxon with climate change. So this is an area that's interesting in that it implicates both First Amendment issues, it implicates corporate law issues, and there's a lot of debate. So what I want to ask our panelists is, does your work on corporate constitutional rights provide any insight on how to resolve some of these questions, and what is the role of disclosures, either in the spending realm or on this more expansive realm under the disclosures? Like, what do you see the role of this? Adam?
Well, I'd say when it comes to disclosure, be careful what you wish for. Disclosure, there are pathologies associated with disclosure. Disclosure doesn't always work. I know there's this old idea about sunlight being the best disinfectant. The thing about sunlight is it also helps things grow. And so take executive compensation, something that grew because of the sunlight of disclosure. 20 years or so ago, we made a big push for increased disclosure of executive compensation. And the idea was, reformers had this idea that if there was more disclosure, then executive could put downward pressure on executive compensation to lead to more restrictive compensation. It had the exact opposite effect. It led to an explosion of executive compensation. Because what happened? Well, when the board was sitting there saying, well, let's hire Erwin Chemerinsky to come be our CEO, they would say, well, what are similar CEOs of similar sized companies and similar industries getting paid? Oh, well, they're getting paid, $500,000. Oh, but Erwin Chemerinsky is better than any of those people. We need to pay him $750,000. And then the next company does that, and the next company does that, and all of a sudden the baseline's $750,000, and the next CEO is getting $1 million. And what we've seen is disclosure has led to an increase in executive compensation. It certainly, if it's not the cause of it, it certainly has not diminished executive compensation. I think we're likely to see that in the corporate political spending situation too. In the short term, we might think that people are going to respond negatively to corporate political spending, but I think that's a function of our era right now. It could be that in 10 years that it becomes more normalized because of more disclosure. Oh, all these other companies in our industry, they're all spending. Let's do it too. We got to keep up with the Joneses, just like we had to keep up with the Chemerinskys in hiring our CEO. And it could lead to actually an explosion of spending. The problem with disclosure is also in part, it is presumed, the idea of disclosure is based on a presumption that shareholders or the capital markets will be able to control corporate management decisions. That may be accurate at a very high level of expenditure. Corporation's going to spend $1 billion, maybe shareholders in the market for corporate control could have some influence on this. It's not going to have any effect on $1 million spending, a $10 million spending, maybe even a $100 million spending campaign by corporations. Shareholders do not control their corporations. The market for corporate control only works at the very most extreme level. So I don't think disclosure is going to have the effect, or at least, I don't know if it's not going to have the effect, at least there's a pathology that could make it very dangerous. It could lead us in the exact opposite direction that reformers who are pushing disclosure are looking for.
Yeah, so I haven't really thought about this for really deeply and very long, but my instincts are to be a radical disclosure advocate. So it's counter to what Adam is saying. I grant his pointing out that it can lead to negative consequences, but I don't think the dynamics are the same in terms of incentive structures and things on disclosure of political spending as they would be on compensation. And even in the area of compensation, the compensation consultants knew anyway. And so the people in the boardroom were going to know what other corporations were paying, even if the shareholders didn't know. So I'm not sure that it was the exposure, that making these things public so that shareholders and so that the Wall Street Journal knows how much CEOs got paid is necessarily what drove up executive compensation. I think there were other factors at work driving up executive compensation. But meanwhile, I think it's critically important that we know who is putting the money out there in political campaigns.
Erwin, did you want to?
I would have said the same thing.
James, what about your work on the securities disclosure side? Do you see that as an area where corporations can use the expansion of corporate constitutional rights to fight off required disclosures under SEC rules?
Sort of one, answering that, but also following on to the discussion of executive compensation disclosure, a common criticism of the idea of disclosing political spending is that it will necessarily decrease the amount of political spending by corporations, and that's in fact the whole goal of trying to mandate disclosure, political spending disclosure. And I think as the case of executive compensation illustrates, that's far from obviously going to be the case, which is to say, I think some people did want, I mean, there are different views as to why there was executive compensation reform, but some people at least wanted it to decrease the levels of compensation, and in fact it had the opposite effect. So I think my view is that we should be skeptical of the idea that, one, mandatory disclosure of corporate political spending is motivated by either trying to defund the right or basically just trying to decrease the total amount of corporate political spending. And we should also be skeptical of the empirical prediction that is behind that idea, which is just because you mandate disclosure that it's going to go down, it might, as in the case of executive compensation, go up.
And Michael King, who's on our second panel this afternoon, has some interesting empirical research on disclosure rules in direct democracy on ballot measures. So hopefully we can continue that conversation.
Yeah, what I just want to say is, I think knowledge is always better than ignorance.
Yeah.
And so imagine there's somebody who's running for the city council. Wouldn't it be good to know if developers spent a great deal of money to get that person elected?
Yeah.
As I evaluate a candidate, one of the things I want to know is who's spending the money to get this person elected? Who's this person likely beholden to?
Right.
If I want to evaluate conflicts of interest down the road, I want to be able to know who spent the money to get the person elected. So whether disclosure leads to more or less money, I think misses the point of why we want disclosure. And to me, this goes back to the distinction I was drawing at the beginning. For individuals, there may be privacy interests in what we tell the world. Corporations don't have intrinsic privacy interests. When it comes to disclosure, it's always a question of instrumentally is it desirable to have this information. And my instinct, as I said, is it's always better to know.
Sarah, does your prior work on distinguishing between the interests of voters versus the interests of shareholders shed any light on this question of corporate disclosures?
So it certainly does. I am not as optimistic as a lot of legal scholars, election law scholars, about the state of disclosure, particularly after Citizens United. So the conventional story is that the last part of Citizens United, which dealt with disclosure and was an 8-1 decision upholding disclosure, was a real endorsement of disclosure by the Supreme Court. And I actually think that a lot of the language in Citizens United about shareholders having informational interests in campaign finance disclosure is actually a real sea change in the way the Supreme Court had been thinking about the purposes that campaign finance disclosure serves, and is a bit of a shot across our bow in terms of where disclosure may be heading. And I suspect that what we're going to find is that public disclosure laws and even the private ordering of disclosure, which I'm studying now, is heading in a direction of shaping corporate disclosure, corporate campaign finance disclosure for a shareholder audience rather than a voter audience. So there are real differences when you talk about a company's political spending. There are real differences in why a voter might care about a company's political spending and how a voter would use that information versus why a shareholder of that company would care about that information and how that shareholder would use that information. And unfortunately, I suspect that we are going to start moving toward disclosure laws that are tailored more toward shareholder interests than citizen interests.
At the election, at the campaign level, or do you mean at the securities level?
Well, so we don't have a securities regulation now that mandates
Right.
corporate political spending disclosure. But so at the electoral, at the level of election regulation, so when we have federal disclosure laws and state disclosure laws as well, actually. North Dakota, a couple of years ago, in their legislature introduced a disclosure statute that they ended up withdrawing. But that made a difference. It had different disclosure thresholds for corporations than for individuals. The idea being if you were an individual spending money to influence a state election in North Dakota, you had a very low threshold of spending that you had to disclose. But if you were a corporation, you could spend tens of thousands of dollars before having to disclose anything. And the reason that makes sense to shareholders is because it ties into ideas of corporate materiality. But from a voter's point of view, making a distinction between corporations and individuals in this way is actually, it undermines our confidence in electoral integrity. It prevents people from understanding how the political process works, et cetera. A lot of things that we consider to be bedrock constitutional values about why we have disclosure. Not just because it causes spending to go up or down, but because disclosure sheds light on something that the citizenry needs to understand well.
Oh, so my last question, I'm going to pose it as a mini quiz in the following. So I'm going to ask a question, and you have options of your answer. I'm going to ask the panelists to choose their answer, and if we have time, to state why they've chosen their answer. So my question is commercial speech. Is it A? Does it provide a way forward for advancing your view of appropriate conceptualization of corporate constitutional rights? Is it B, in jeopardy, is it in jeopardy sort of post these decisions we've been discussing in this Roberts Court? C, is it a law school exam relic and for law school exam knowledge only, but not a really useful tool for thinking about any of these issues? Or D, some combination of both? So, Margaret, I don't think I've started with you yet on any of these.
I didn't hit the button first.
You didn't. Does anyone want to hit the buzzer? Who's hitting the buzzer?
No, I'll take it. So, okay, so I think to a certain extent, the distinction we make between commercial and political speech is probably not even relevant anymore. Once you allow all other kinds of speech, then saying, well, but commercial speech we still have the right to regulate. Maybe a relic. I don't know of any cases that have come down about it recently where anybody has tried. I guess there are cases. The case about Exxon and whether or not they told the truth in the public statements they made. That is a political speech kind of case. And I think the distinction that I'm groping for in right now is that who has the ability to enforce whatever restrictions on speech are we talking about? Is it the shareholders that have a right, or some other parties that are affected by corporate speech that have the right to come in and complain that the corporation misled the public or lied about what they were doing or that sort of thing? Or is it a criminal thing that they engaged in an activity that was illegal in the sense that they were paying bribes to politicians and elected representatives and that sort of thing. So I think the distinction may still be there, but it strikes me as probably not very important anymore.
Okay, James?
I guess I'll be quick. I am not optimistic that pressing the doctrinal distinction between commercial speech and political speech will lead to, is a fruitful avenue, is a good way forward. So that eliminates A, right? And so I think some
I like your strategy, that you're
Right.
going with what's not the right answer.
Right.
Determine
This is
what
how I
your
took the
answer
SATs,
is.
right? You're supposed to get rid of enough. And so I guess that leaves B and C, and both of those sounded pretty good to me, which I suppose makes me in D, some combination.
Some
of the,
combination based on-
of the above, especially, in light of recent, the Sorrell case and other cases that threaten at least to erase the distinction. I'm not sure it's a fruitful path forward.
Thank you for showing your work, James.
Sure.
Erwin, Adam, want to weigh in? No. See, it does.
I'm the student who fights the hypothetical. I'm choosing E, none of the above.
Okay.
Let me start by saying I disagree with those who've said the distinction doesn't matter. I think the distinction between commercial speech and political speech matters very much. False commercial speech is not protected by the First Amendment. False political speech is protected by the First Amendment. And so if Listerine says it kills cold germs when it doesn't, that's something that can be punished. If a product says it was made pesticide-free or tuna was caught without killing dolphins and that was false speech, that can be punished. But in the realm of political speech, false and deceptive speech has to be protected. That's to me why we have to keep the distinction between commercial and non-commercial speech, even though there can be a gray area. Now, I think the question is, the Supreme Court has over many years said that commercial speech is less protected, and so it gets intermediate rather than strict scrutiny. Wentworth versus Florida Bar says that, the Central Hudson test that. I think the interesting question is, do cases like Sorrell or more recently Reed versus Town of Gilbert point to a court that might shift to strict scrutiny in evaluating regulations of commercial speech, and what would that then mean?
Very good. Adam?
Yeah, so I think I agree with Erwin that we need to keep the distinction between commercial speech and political speech very firmly drawn. And I think the problem with Citizens United in part is the court defined the corporate speech of a corporation to be political speech, not commercial speach. All speech of a corporation should be commercial speech. Corporations, at least for-profit corporations, I should suggest, for-profit corporations, management has a fiduciary duty to only act in the interest of the corporation. That generally means maximizing shareholder wealth, at least in the long term. You might have some disagreement about whether it means in the short term, but if your corporate policy or your corporate agenda leads to the inevitable bankruptcy of your corporation, it will be a violation of your fiduciary duties. So you have to act in the long-term interests of shareholders at least. I think that means anytime a corporation makes a political expenditure, it's making commercial speech. It's trying to advance its business and its business opportunities and its brand. So I think we should have a distinction between commercial speech and political speech, but corporate political, what we often think of as corporate political speech, should be thought of as corporate commercial speech, subject to more regulation. Another thing about commercial speech, though, that should, again, prove another warning. I said, about sunlight, that also leads to some pathologies. There's also the pathology of progressive reform being turned around and used for pro-business purposes. We see that over and over again, and commercial speech is a perfect example. The commercial speech doctrine was the result of a case brought by Ralph Nader to expand the rights of consumers in the Virginia pharmacy case. Because Ralph Nader didn't want to represent a pharmacy and a pharmacist, he made an argument based on listeners' rights. Whose rights were involved? Well, they didn't have any pharmacists who had been silenced as plaintiffs. So they couldn't make an argument that the pharmacists were silenced. They had to make the argument that the listeners, the consumers who Ralph Nader represented, were injured. And that won the day. And then that becomes the basis of Bilotti. And the argument in Bilotti for expanding corporations' rights, that it's about listeners' rights. That idea appears again in Citizens United. And today, we see that Public Citizen, where Ralph Nader led this charge for commercial speech rights, is now leading the charge to overturn all of the commercial speech doctrine because it's being used almost exclusively by corporations and by businesses to hurt consumers rather than to help consumers. So it's I think commercial speech itself is a story that has some warnings about when we think about reform, thinking about the long-term consequences of reform and how it might really operate and be turned against the very progressive goals that people are pursuing.
Thank you. Sarah?
Gosh, I just agree with everything that you just said. I'm just,
Hug?
I really like that. Well, so it seems to me the Supreme Court has been creating these functional categories that apply to corporate speech. You've got your securities regulation, which can restrict or compel speech. You've got your commercial regulation that can restrict or compel commercial speech. Campaign finance disclosure, political speech can be restricted or compelled. And these functional categories, which we're seeing play out in cases like NAM v. SEC, they don't work. The functional categories don't work. They're unmanageable. And this this simple, effortless principle that when a corporation speaks, it is engaging in commercial speech, is such a great idea, and really I think is a simplification that captures all the nuance that needs to be captured in that one idea. So I like that.
You want to write an op-ed? Let's get an op-ed on this.
You're on.
All right, well, thank you to our panelists. A great discussion. Thanks to our audience members. I know we've got another panel.
That is good.